What type of evidence is used in Guantanamo Bay tribunals? Have you ever wondered what kind of evidence is used in the Guantanamo Bay tribunals? The military commissions and combatant status review tribunals at Guantanamo Bay utilize a mix of evidence types, but many aspects have drawn criticism. Let's break it down. First, a significant portion of the evidence is classified and secret. This means that detainees and their defense teams often cannot see or fully challenge this evidence. The tribunals usually assume this classified information is reliable, even though detainees have limited chances to confront it directly. This lack of transparency can make it hard for detainees to build a solid defense. Next, there are restrictions on witness testimony. Detainees can typically only call other detainees as witnesses, who are also presumed to be enemy combatants. Requests to bring in outside witnesses, especially those who might support the detainee's innocence, are often denied. This limitation severely impacts the defense's ability to present a complete case. When it comes to documentary evidence, detainees can introduce some documents, but this is often limited to personal letters from family or friends. Even when detainees try to present documents that could prove their innocence, like passports, these are frequently rejected. This further weakens their defense. An important point to note is that statements or evidence obtained through torture or cruel treatment are not allowed in these military commissions. This includes any statements made by detainees under such conditions. However, evidence about torture itself may be used in specific contexts, such as to show that a statement was made, but not as proof of guilt. Lastly, the tribunals operate under standards that differ from civilian courts. There is often a presumption of guilt, with the government's evidence being favored. Detainees have fewer protections and less ability to challenge the evidence against them. From a Latin cultural viewpoint, where legal traditions often stress due process and the right to a fair trial, the evidence practices at Guantanamo Bay raise serious human rights concerns. The limitations on evidence access and the use of secret evidence contrast sharply with justice principles valued in many Latin American societies. The history of human rights struggles in Latin America, including battles against torture and unfair trials, informs a critical perspective on the evidentiary methods used at Guantanamo Bay. In summary, Guantanamo Bay tribunals relying heavily on classified evidence, restrict detainees' ability to present witnesses and documents, exclude torture-derived statements, and operate under standards that often disadvantage detainees. These practices highlight ongoing questions about justice and human rights.